check your belongings.
I'm attorney Alicia Brooks. You have no right to intimidate me.
You think you're above the rules? I want to check your car.
I do not consent to any unlawful search. Step back immediately.
Don't test me, ma'am.
And don't violate my rights. Everything is recorded.
We'll see about that.
Then we will.
And just like that, a routine evening became the beginning of a case that would expose years of abuse and cost the department hundreds of thousands of dollars. Alicia Brooks wasn't just any attorney. She was a federal judge appointed after nearly 2 decades of civil rights litigation. Her career had been built on constitutional law, unlawful searches, and government accountability. She had argued cases involving racial profiling, excessive force, and abuse of authority. And now, she found herself standing alone, being treated as a suspect for no reason other than existing in the wrong place at the wrong time. She had just left a late judicial conference held at a nearby federal building. The parking lot was mostly empty, illuminated by overhead lights and monitored by security cameras. Alicia had taken this route countless times before. Nothing about her presence was unusual. Nothing about her behavior was suspicious. Yet the officer standing in front of her had already decided otherwise. He was a private security officer contracted to patrol the federal complex after hours. Mid-30s. Confident. Too confident. The kind of confidence that comes from knowing complaints rarely stick. "What's the reason for this stop?" Alicia asked. "I don't need to explain myself," he replied. "Step out of the vehicle." Alicia stayed seated. "Am I being detained, or did I commit some violation?" The officer's expression hardened. "I said step out. Now." Alicia slowly opened the door and stepped onto the pavement, keeping her hands visible. Years of courtroom experience had taught her something important. Escalation benefits the person with authority, not the person with rights. Still, she could feel it. That familiar, sinking awareness that this wasn't about security. This wasn't about procedure. This was about power. The officer positioned himself too close, invading her personal space. His eyes scanned her car with exaggerated suspicion. "You got anything I should know about in there?" he asked. "My personal belongings are none of your concern," Alicia replied. "You have no probable cause." The officer laughed under his breath. "You lawyers always say that." "I'm not just a lawyer," she said. "And even if I were, the Constitution still applies." That was the moment his tone changed. He didn't like being challenged. He didn't like being corrected. And he definitely didn't like that she was calm. "Turn around," he ordered. "For what reason?" "Officer safety. No weapons. No threat. No justification," Alicia said. "This is harassment." Instead of responding, the officer reached for his radio. Within minutes, another security vehicle pulled into the lot. A second officer stepped out, younger, quieter, watching carefully as the situation unfolded. Alicia noticed the hesitation in her body language, the look of someone unsure whether this had already gone too far. The first officer spoke quickly, framing the narrative before Alicia could. "She's being uncooperative, refusing consent, acting suspicious." Alicia turned toward the second officer. "I've done nothing wrong. I've asserted my rights. That's not a crime." The second officer didn't answer immediately. Instead, she asked, "Sir, what exactly is the issue here?" The first officer waved her off. "I've got it handled." Handled. That word would become important later. Because what happened next wasn't handling a situation, it was creating one. The officer informed Alicia that he was going to detain her temporarily while he conducted a security check of her vehicle. "I do not consent," Alicia said clearly. "You are exceeding your authority." "Turn around," he repeated. When she didn't move fast enough for his liking, he grabbed her arm. That single act, captured on camera, would later echo through a courtroom. A federal judge. Grabbed. Detained. Without cause. And this was only the beginning. The moment the officer's hand closed around Alicia Brooks' arm, the balance of the encounter shifted. Not legally. Not constitutionally. But psychologically. Alicia didn't resist. She didn't raise her voice. She didn't pull away. She knew exactly how moments like this were later rewritten in reports. Instead, she said one sentence, slow, clear, and deliberate. "You are detaining me without legal justification." The officer ignored her. He guided her toward the front of the car, positioning her beside the hood. The metal was cold beneath her palms as he instructed her to place her hands flat against it. The second officer stood a few feet away, silent, watching. "This is unnecessary," Alicia said. "There is no threat. There is no violation." The officer responded without looking at her. "People who have nothing to hide don't make things difficult." Alicia closed her eyes for a brief moment. She had heard that phrase countless times, in transcripts, in depositions, in police testimony. It was always used the same way. To reverse responsibility. To justify intrusion. Her car door was still open. Without waiting for consent, the officer walked toward it and leaned inside, shining his flashlight across the interior. He opened the glove compartment. He checked the center console. He moved with confidence, as if this was routine, as if it was normal. "It's being recorded," Alicia reminded him. "Good," he replied. "Then you'll have nothing to complain about." But she already knew that wasn't true, because recordings didn't prevent misconduct. They just documented it. The second officer shifted uncomfortably. "Sir," she said quietly, "what exactly are we looking for?" The question hung in the air longer than it should have. The officer didn't answer immediately. "Contraband," he finally said. "Anything illegal." "Based on what?" she asked. "Experience." Alicia turned her head slightly. "Experience isn't probable cause." That was when his patience snapped. "Stop lecturing me," he snapped back. "You're not in charge here." "No," she replied evenly. "But the law still is." The officer slammed the car door shut and turned back toward her. "You keep talking like that, and this gets a lot more complicated." That threat, subtle but unmistakable, was captured clearly by the audio. Complicated. For who? The officer returned to his vehicle and began typing into his system, running Alicia's information. Her identification had already been verified. Her record was clean. No warrants. No alerts. Nothing. It should have ended there. Instead, it dragged on. Minutes passed. Alicia stood by the hood of her car under the bright parking lights while traffic moved distantly beyond the complex. She could feel the eyes of the second officer on her. Curious, conflicted, uncertain. The first officer remained inside his vehicle longer than necessary. Later, internal logs would show he wasn't just running information. He was calling a supervisor, not to clarify procedure, not to de-escalate, but to protect himself. When he finally stepped back out, his demeanor had changed again, more rigid, more defensive. "Step away from the vehicle," he ordered. "For what reason?" Alicia asked. "You're interfering with an investigation." "There is no investigation," she replied. "You haven't articulated one." That was the moment the second officer spoke up again. "Sir, we don't have anything here." The first officer shot her a look that said enough. He reached for his cuffs. Alicia's heart pounded, not from fear, but from disbelief. "You're about to make a serious mistake," she said. "Turn around," he ordered. "I am a federal judge," Alicia said calmly. "And I am telling you this stop is unlawful." The officer froze. "What did you say?" "I am Judge Alicia Brooks. Federal District Court." For a split second, uncertainty flickered across his face. Then it disappeared, replaced by something worse. Disdain. "Yeah," he said. "Prove it." Alicia offered to show her credentials. He glanced at them briefly, then scoffed. "Could be fake." That was when the second officer finally stepped closer. "Sir, maybe we should." "No," he interrupted. "She thinks her title makes her untouchable." "That's not what I said," Alicia replied. But it didn't matter. The narrative had already been written in his mind. He pulled her hands behind her back. The click of the cuffs echoed louder than it should have. Alicia stood there, restrained, humiliated, unlawfully detained, while her vehicle was searched from front to back. Briefcase opened, documents handled, personal items examined, all while she stood in silence, memorizing every detail. Because Alicia Brooks didn't just know the law. She knew how cases were built, and she knew this one was far from over. Once the handcuffs were secured, the officer stepped back as if the decision had already been justified. "You're being detained," he said. "For what charge?" Alicia asked. "You'll find out." That answer alone violated procedure. Charges don't come later. They come first. Alicia was guided toward the security vehicle and placed in the back seat. The door closed with a final, mechanical thud. From inside, she could still see her car through the window. Doors open, trunk lifted, her belongings laid bare under fluorescent light. Every move was being recorded. Every word was being captured. And yet, no one stopped it. The second officer stood nearby, arms crossed, her expression tight. She hadn't participated in the search. She hadn't stopped it either. Silence, in moments like this, carried its own weight. Inside the vehicle, Alicia took a slow breath. Years of courtroom discipline kept her composed, but beneath the surface, something else was happening. Not panic, recognition. She had presided over dozens of cases like this. She had heard defendants describe the same sequence of events: the vague suspicion, the refusal to explain, the escalation, the cuffs. From the bench, those stories had always sounded troubling. From the back seat of a patrol vehicle, they felt different. The officer returned after several minutes, clipboard in hand. "You're being charged with obstruction and failure to comply." Alicia looked directly at him. "I complied with every lawful order." "That's not how I see it. That's not how the law sees it either." He ignored her. She was transported to a local holding facility operated in coordination with federal security services. The ride was quiet. The officer didn't speak. Alicia didn't either. When they arrived, the routine began. Fingerprinting, photographs, personal property logged and bagged. No explanations, no apologies, no acknowledgement of the absurdity of it all. The intake officer paused when he reviewed her information. "Ma'am, you're a judge?" "Yes." He hesitated. "That's not what we usually see for this kind of charge." Alicia met his eyes. "Neither is this kind of arrest." She was placed in a holding area with several other women, none of whom recognized her at first. She sat quietly on the bench, hands folded, posture straight. Time passed slowly. Eventually, word spread. Whispers. Double takes. Questions. A federal judge. Arrested. Detained. For obstruction. It didn't make sense to anyone. After several hours, Alicia was released without explanation. No charges filed. No paperwork beyond a brief notice of detention. She stepped out into the night, collected her belongings, and drove home in silence. But sleep didn't come. By morning, she had already made her decision. This wouldn't be handled quietly. Her first call was not to the department. It was to a civil rights attorney. And once that call was made, the past caught up with the officer who thought he could get away with it. Because Alicia Brooks wasn't the first person he had stopped like this. She was just the first who couldn't be ignored. Over the following weeks, the story began to spread, quietly at first. Among attorneys, among judges, among people who had heard the officer's name before. Patterns emerged. Complaints resurfaced. Men and women who had once been dismissed began to speak again. Professionals, business owners, students, all describing the same thing. The same tone, the same suspicion, the same escalation. Internal records revealed what oversight had failed to address for years. Multiple complaints, minimal investigation, no consequences, each incident isolated, each one dismissed. Until now. Because this time, the person he detained knew exactly how to expose it. And she intended to do just that. The lawsuit was filed quietly at first. No press release. No media interviews. Just a federal civil rights complaint outlining unlawful detention, illegal search, and abuse of authority. But the moment the officer's name appeared on the docket, something shifted. Attorneys recognized it. So did a few court clerks. And within days, stories that had once gone nowhere began resurfacing. The first call came from a civil litigator who had represented a small business owner years earlier. He remembered the stop vividly: late night, vague suspicion, aggressive tone. The complaint had been dismissed without explanation. Then a criminal defense attorney reached out. He had represented a college student detained for nearly an hour during a routine stop. No charges, no apology, just humiliation. Another call followed, and another. Each story followed the same structure. Professional, compliant, targeted. Alicia's legal team began assembling the record. Not emotionally, not rhetorically, methodically. They pulled internal complaint logs, training records, supervisor evaluations, dispatch reports. What they found was worse than expected. 17 complaints over several years. 14 involving black motorists. Most closed within days. Some without interviews. Others with missing footage. In nearly every case, the officer's explanation was accepted at face value. Suspicious behavior. Failure to comply. Officer safety. Language so vague it protected everything and explained nothing. One case stood out immediately. A surgeon stopped while driving to an emergency procedure. Detained for over an hour. No citation. No contraband. Complaint dismissed. Another involved a young attorney pulled over after a late court appearance. Her vehicle searched. Her career questioned. Footage unavailable. A construction business owner described being accused of driving a stolen vehicle, his own. Detained while ownership was verified. Records later showed no stolen vehicle report existed. Each incident alone might have been overlooked. Together, they formed something undeniable. A pattern. The second officer from Alicia's stop, now under subpoena, began to feel the weight of it. She had replayed that night in her mind more times than she could count. The tone, the escalation, the moment when everything crossed a line. When investigators asked her to give a formal statement, she hesitated. Not because she didn't know what happened, but because she understood what telling the truth would cost. Department culture was clear. You don't contradict your partner. You don't create problems. You don't speak out. Still, the questions kept coming. Why was no supervisor called sooner? Why was no charge articulated? Why was the search conducted without consent? There were no good answers. Meanwhile, Internal Affairs reopened files long thought closed. Training logs showed the officer had not received updated instruction on constitutional stops in years. Performance reviews praised initiative and assertiveness without addressing complaints. Supervisors had been warned. They had chosen not to act. As the case moved forward, the department's insurance carrier stepped in. They saw what leadership had ignored. This wasn't a single incident. It was exposure. Settlement discussions were suggested. Quiet resolution. No admission. No precedent. Alicia declined. This wasn't about money. This was about record. Because for every case dismissed quietly, someone else paid the price. And this time, the record was being built properly. Publicly. Carefully. Irrefutably. The officer was placed on administrative leave pending trial. His confidence faded. The certainty that had once protected him was gone. Because for the first time, the system was no longer shielding him. It was watching him. Pressure doesn't always arrive loudly. Sometimes it comes in silences. The second officer noticed it first in the break room. Conversations stopped when she entered. Invitations disappeared. Her name was left off schedules she had always been part of. No one said anything directly. They didn't have to. The message was clear. Loyalty was expected. Truth was optional. Supervisors began framing conversations carefully, never instructing her to lie, never explicitly telling her what to say. Instead, they asked whether stress might have affected her memory, whether certain details might be less clear than she thought. One lieutenant reminded her that careers in law enforcement were built on trust. Another mentioned that officers who caused internal conflict often found advancement difficult. The implication sat heavy. Meanwhile, the officer at the center of the case grew increasingly defensive. He insisted he had done nothing wrong. He framed the lawsuit as an attack on authority, on order, on enforcement itself. In internal meetings, he claimed the judge had been hostile, uncooperative, provocative, but every claim ran into the same problem. Video doesn't argue. Footage showed compliance. Calm, clear communication. No threats. No resistance. No justification. As trial approached, more complaints surfaced. A college student, a physician, a delivery driver, each describing the same pattern. The department's legal team reviewed the data and realized something important. This wasn't about one night. It was about what had been tolerated. Statistical analysis showed the officer stopped black motorists at a rate far exceeding his peers. His search rate was even higher. Yet his success rate, finding anything illegal, was lower. There was no public safety explanation for that. Only bias. Insurance attorneys warned leadership. If this went to trial, damages wouldn't be limited to one case. Punitive damages were possible. Policy failure was provable. Settlement was recommended again. Again, Alicia declined. She wasn't interested in quiet resolution. She wanted testimony. As trial preparations intensified, the second officer faced her final decision. Stay silent or speak. She sought advice from someone she trusted. Her father, a retired officer who had served decades without a single sustained complaint. She described the incident without names. He didn't hesitate. If what you saw was wrong, he said, then the badge doesn't excuse it. It makes it worse. That settled it. Days later, she contacted Alicia's legal team. Her statement was detailed, careful, honest. She described the moment escalation became unnecessary. The lack of cause. The comment about teaching respect. That statement changed everything. The department could no longer claim misunderstanding. One of their own had confirmed it. The officer's defense collapsed before the trial even began. Public attention followed. Media coverage grew. Community groups demanded accountability. Leaders were forced to respond. And for the first time, the wall held no longer. The courtroom was full before the doors officially opened. Journalists lined the back rows. Civil rights observers filled the gallery. Every seat mattered, because everyone knew this case would set a record, whether the department wanted it to or not. Alicia Brooks entered calmly, dressed in a neutral suit, her expression controlled. She didn't look at the officer seated across the room. She didn't need to. The facts would speak. Opening statements laid everything bare. A routine evening. No violation. No threat. No cause. The prosecution walked the jury step by step through the encounter. How authority was asserted without justification, how rights were ignored, how escalation replaced reason. The defense leaned on familiar language. Split-second decisions. Officer safety. Professional judgment. But the words rang hollow when placed beside the video. Frame by frame, jurors watched calm compliance met with increasing aggression. They heard the refusal to explain. They saw the search without consent. They listened to the phrase that changed everything. She needs to learn respect. Expert witnesses followed. Former supervisors testified that procedure had been violated. Civil rights analysts explained the statistical pattern of targeting. Training specialists described the department's failure to intervene despite repeated warnings. Then the second officer took the stand. Her voice was steady. She didn't embellish. She didn't speculate. She described exactly what she saw. The courtroom went quiet when she confirmed there was no legal basis for the detention or search. The defense tried to discredit her. Suggested confusion. Suggested pressure. Suggested loyalty conflicts. She didn't waver. I took an oath, she said. It wasn't conditional. Alicia's testimony came last. She didn't speak as a judge. She spoke as a citizen. She described the humiliation of being restrained without cause. The disbelief of realizing knowledge and position offered no protection. The fear, not of arrest, but of power exercised without restraint. When deliberations began, they didn't last long. The verdict was unanimous. Liability found. Rights violated. Damages awarded. $680,000. The courtroom didn't erupt. It didn't need to. The message was clear. The officer was terminated. His record no longer shielded him. Pension benefits were forfeited. The department announced policy changes under public scrutiny. Mandatory training. Independent review. Preservation of footage. Alicia donated the settlement to a legal defense fund for victims of unlawful detention. She returned to the bench weeks later, unchanged in demeanor, but strengthened in resolve. Because the law only matters when it's enforced equally. And sometimes, accountability doesn't arrive quietly. Sometimes, it arrives on the record.